SRIRAM's IAS, serving the nation since 1985. Ab offline, hoya online, we are the lifeline.
Hello students, welcome to SRIRAM's IAS. I'm Mayank Bharadwaj presenting you with this Polity Current Affairs classes. This is our class number 10 and this will be very helpful for your upcoming prelims examination. Let us come up with, we have come up with a new topic and see the slide. There has been an order passed by Lokpal. Now everybody know that in 2013 Lokpal and Ayukt Act was passed. Lokpal is under the aegis of the executive. This is the part of executive, works under executive sort of, and complaints can be made even for higher constitutional posts to Lokpal in the matters of corruption. So the point is, does the judiciary comes into Lokpal Act or not? The jurisdiction of Lokpal extends to the High Courts or Supreme Court or not? Now this is the issue of contention here. In this slide we are going to see that Supreme Court has stayed Lokpal's order giving itself jurisdiction over High Court judges. Now the judiciary is watching this issue as interference in the judiciary, become a matter of judicial independence. We are going to see this. So the Supreme Court also issued a notice to the Union government and sought assistance of Solicitor General, Senior Advocate and P.B. Suresh. These are the lawyers and the Supreme Court is asking for their help in this matter. So what has the Lokpal said? Now this is the statement made by Lokpal. We make it amply clear that by this order, they have passed an order. They have actually passed two orders. One was the order on 3rd of January. And there was another order on 27th of January. This was in relation to the Supreme Court and this is in relation to the High Court. Now, the order which was passed on 3rd of January in relation to the Supreme Court was alright. There was no issue and the Supreme Court has not taken it negatively. But this one, 27th January order of the Lokpal, which was passed for the High Court in relation to the High Court, has been taken up by Supreme Court in a suo motu cognizance, and they have raised the issue of executive interference in the judiciary. It has become a national issue now and people are talking about it. We make it amply clear, and this is the order of 27 January. The order is written here that we make it amply clear. This is the language of the Lokpal. That by the order we have decided a singular issue. What is that issue? As to whether the judges of the High Court established by the Act of Parliament come within the ambit of section 14 of the Act of 2013, section 14(1)(f) of the Lokpal and Lokayukt Act of 2013. So they have singularly decided on the fact that whether High Court judges, those High Courts which are established by the Act of Parliament, do they come under the jurisdiction of Lokpal or not? In the affirmative, that simply means according to the judgment of the Lokpal, the judges of the High Court do come under the jurisdiction or under the definition given under section 14(1)(f) of this Act of 2013. More and no less. In that, we have not looked into or examined the merits of the allegations at all. Okay. So, in order to understand this issue, let's understand that a complaint has reached the Lokpal few days back. The complaint was regarding an additional judge of the High Court. And the complaint was that the additional judge has influenced two other judges, one more additional judge and the other judge of the same High Court, to give ruling in favor of one party. Okay, this complaint has reached the Lokpal, and once it has reached the Lokpal, the question came whether the judges of the High Court and the judges of the Supreme Court are under the ambit of Lokpal or not. A very big issue was there around Lokpal. Anna Hazare was sitting on fast onto death, and Parliament simultaneously was involved in passing the Lokpal and Lokayukt Act in 2013, it became a very big issue, the very big issue of corruption before the Modi government in 2014. So this act was the highlight, but does it involve judiciary as well? Again, there are three organs: this is a judiciary and parliament. Now the speaker, the members of the parliament, the council of ministers, here the prime minister, the ministers, other ministers, everybody comes under the ambit of Lokpal. But what about judiciary? Does judiciary come under the ambit of Lokpal or not? Not explicitly written anywhere, because these are constitutional bodies created for maintaining justice in the society. So if they come under the ambit of Lokpal, which is in a way under the edges of executive, don't you think that there will be executive interference in the judiciary? Now it's a matter of debate, but judicial pronouncements and judiciary at this point of time does not permit any kind of interference. We have also seen in the issue of National Judicial Appointment Commission, which was scrapped because of the basis that it was interfering the judicial independence. So let's see the context of this. A 7-member Lokpal bench headed by the former Supreme Court judge held that sitting judges of the High Court established through the Acts of Parliament fell under the purview of the Lokpal and the Lokayukt Act of 2013. Now, if you see the act, the purpose of this act is this: act to provide, we are talking about the Lokpal and Lokayukt Act here, to provide for the establishment of a body of Lokpal for the union and Lokayukt for the states. Okay, Lokpal for union, Lokayukt for states, to inquire into the allegations of corruption, any kind of corruption made against certain public functionaries for the matter connected therein and incidental thereto. Lokpal bench, this 7-member bench, have cited this section, okay, section 14(1)(f) of the Lokpal and Lokayukt Act. What did this particular section says? It says that any person, this is very important terminology here in this particular section, that any person who is or has been a chairperson or a member or of or employee in any body. Now these two have became the bone of contention, any person. So the 7-member Lokpal bench have said that any person also involves judge of High Court, any person, and the body here, any body which is established by an act of parliament. So they say that the high courts are established by the act of parliament, and for that reason any person must involve the judges of the high court, okay, and anybody must involve high courts as well. Okay, I hope you have understood this section 14(1)(f). This in a way tells that the complaint against which authority can be filed, who is involved in which body in any post. Simply means section 14 defines the jurisdiction of Lokpal and Lokayukt, that any person who is officer in any body which is established by the act of parliament, a complaint can be filed against that particular person. So in the interpretation made by the Lokayukt, they have included the judges of the High Court on the basis that High Courts are established by the act of parliament. Now, after this judgment, the Supreme Court has taken into consideration this particular act under Article 32. They have taken suo motu cognizance. They have taken suo motu cognizance. They have picked up this particular judgment of the Lokpal and said that it is very, very sad that such an interpretation has came up. Why have they said it? We are going to understand. So we have already understood the contradiction in the orders, 3rd January order and 27th January order. Here what happened? In 3rd January order, Supreme Court was to the question that whether Supreme Court and the judges of the Supreme Court come under the jurisdiction of Lokpal or not. Comes under the jurisdiction of Lokpal or not. So Lokpal has ruled that since Supreme Court is established by the Act of Parliament and under Article 124, it is a constitutional body and it does not come under the jurisdiction of Lokpal. But in 27th January order, it has ruled something else. It has said that high courts which are made under the Act of Parliament, they do come under the jurisdiction of Lokpal. Now, while the Supreme Court has taken the suo motu cognizance, it has said that how can you make such a distinction? How can you make such a contradiction? The Supreme Court is established under Article 124. Similarly, the establishment of High Court is done under a different article of the Constitution. Okay. You cannot say that Supreme Court is a constitutional body whereas High Court is not a constitutional body. This cannot be said. If you see Article 217, okay, or you see Article 214 or 220, all these tells a great deal about high courts. The establishment of high courts can be seen in Article 214. You say in order number 1 that Supreme Court is established under Article 124, it's a constitutional body and hence it does not come under the jurisdiction of Lokpal. How can you say that high courts which are made under the Act of Parliament will come under the jurisdiction of Lokpal? You cannot say this because high courts are also established under Article 214. Their basis, the source of the establishment of high court is there in Article 214, and that is why this is also a constitutional body. So both high court and Supreme Court must be kept outside the jurisdiction of Lokpal. I hope you understood this particular case. Okay. So high courts drive power from Article 214. Judges are constitutional appointees, not government officers. Judicial independence cannot be compromised. This is important. And Lokpal oversight on high courts, judges equals to the threat to judicial independence, and that is why this case has been taken so seriously by the Supreme Court, taking suo motu cognizance in the matter. Now, the Constitution already has mechanism for judicial accountability. Now, why Lokpal wants to take up this matter and why Lokpal wants to put High Court judges in the ambit of its jurisdiction? Because we have already discussed one additional judge was influencing two other judges to give judgment in favor of a particular person or a particular party. Now, this is a case of corruption. All right. Now, who is going to look after this? Lokpal, or there is some other mechanism? There are some other mechanism. Now, what are the mechanism for judicial accountability? There is impeachment under Article 124, Clause 4 and 217. A judge can be impeached. An inquiry can be made and both the houses of the parliament can pass the resolution for removal of the judge. This is one very strong process or mechanism for judicial accountability. Similarly, internal disciplinary oversights are there. Internal disciplinary oversights are there by Chief Justice. So, if you see a Veeraswamy case was there, we are going to discuss about that case. Supreme Court has put an added layer that if something is found against a judge, that particular thing has to be placed in front of, by the President, has to be placed in front of the Chief Justice of India. Now, the Chief Justice of India decides whether the judge against whom the complaint has come is really the culprit in the matter or not. This is an additional layer which has been provided. Also, if you see section 70 of the Indian Penal Code, section 77 of the Indian Penal Code and section 15 of the Bharatiya Nyaya Samhita, what do they say? Effectively states that a judge cannot be charged with an offence if the allegation is related to the exercise of her official duties. Okay, so if a sitting judge is doing something, does not matter judge of High Court or Supreme Court, if they take any decision in the judicial capacity, in their official capacity, they cannot be charged with the allegations. It cannot be done. There are different mechanisms for that. At least Lokpal will not come into the matter because it can be considered as a executive interference in the judicial matters. Okay, I hope you have understood the whole idea of this particular case. That it is the case of executive interference in judiciary. Lokpal have ruled in two different orders, two different things which are very contradictory to each other. On one hand, it has kept Supreme Court out of its ambit, but in the other order, it has kept high courts under its ambit. Now, the Supreme Court has said this is very, very disturbing. You cannot contradict both of these things because the High Court and the Supreme Court both are constitutional bodies created under the Constitution. There are specific articles related with it. Okay. Supreme Court's concerns. So, what are the concerns? Judicial independence is one concern, legal consistency is another concern, and precedent risk is another one. So, these are called, see, Article 50, separation of judiciary from executive is a fundamental feature of the Constitution, and that is the reason why the executive should not meddle into the affairs of judiciary, because they can influence, and in turn they can influence the delivery of justice. They can gain some favor from judiciary if they try to meddle into the affairs of judiciary. Does not matter whether the matter are of corruption or any other matter. If there is some sort of corruption or judicial misconduct done by the judges, then there are mechanisms for it, and the Supreme Court very strictly do not allow any executive interference. Hence, the interference made by the Lokpal was stopped, was criticized, and the next order is going to come on 18th of March. 18th of March, there is next hearing in this case, that what will be the future of the order made by the Lokpal with regard to the High Court judges. So, this was our slide, this was our presentation on the issue of Lokpal's order, which was trying to bring the high courts under its jurisdiction. That would have amounted to executive interference in the judiciary, which was not promoted and which was not appreciated by the Supreme Court. So, thank you very much for joining me. I hope this thing has helped you and will help you in your upcoming prelims examination. Thank you very much. We will meet in the next class. Jai Hind.